So use the chat for questions and comments, and we'll also have some time at the end of the webinar to answer your questions. So our topic today is on special needs planning. I'm sure we would all agree that the pandemic has really shown us that life is full of uncertainties, and as parents, we are worried about our kids. We're especially worried about our kids with special needs because they're so vulnerable and they're so dependent on us, and we want to do what we can to protect them. And our speaker today is Ellen Cookman. She's an attorney. She is also the owner of Cokeman Law in Palo Alto, and she specializes in special needs planning. And when I talked to Ellen a couple of weeks ago, I was surprised to learn that she used to teach. And Ellen, I believe your husband is also a teacher, is that right? I'll turn the time over to you.
Oh, thanks. Yeah, he was a special education teacher for about 10 years. Yeah. Well, thank you so much. I'm going to do the share screen. Let's see if I can figure this out. Okay, here it is. From the beginning. Great. And then I'll move this over. All right. Thank you so much for everyone joining on a nice sunny afternoon. It's so lovely out. My name is Ellen Cookman, and I actually, let me let you know how I got into this field in the first place. I've been practicing law for 17 years now, and I've been doing estate planning for 11 years. And I love what I do. I actually didn't start liking being a lawyer at first. I worked at Morrison and Forrester for 3 years doing litigation, and it was awful. And then I completely burned out, and I went to teach for a year at the Hope Technology School, which does full inclusion of typical and special needs kids in Palo Alto. And while I was there, I attended a parent support group where somebody was presenting about special needs planning. And I thought, oh, I think that's something I could do. And so I looked into the field and ended up doing estate planning and special needs planning. So a little bit about me. So I'm a certified specialist. That's what most attorneys care about. That's through the state bar. I have my JD from UC Berkeley and my LLM in estate planning at Golden Gate. As Gloria mentioned, my husband was a special ed teacher for 10 years, and now he's home with the boys. And I think he's happy not to be teaching right now because it's really hard. My hat is off to all the teachers who are trying to do distance learning. And coming full circle, both of my kids now attend the same school, Hope Technology School. And my older son, my 7-year-old named Caleb, he has high functioning autism. He was diagnosed 3 years ago. So I went from working in the field to becoming a parent of a child with special needs. So it's been quite a journey. He's doing great, but you know, I'm pretty aware now of the expense and the time, you know, just to get your child to be able to interact with the rest of society. So let me talk a bit about special needs planning. And if you have questions, please type them in the chat box, and we'll pause several times during the presentation to answer your questions. I come from a family of lawyers and teachers, so I love the kind of instructional nature and, you know, making sure that you guys really understand what's happening. Okay, so when we're talking about estate planning, especially estate planning when we have a child with special needs, we have several goals. And our biggest goal is to maximize our child's quality of life and let them be as independent as possible. We're looking to see what happens when we're gone, or if we're disabled and we can't take care of our child. How will we create a financial surrogate parent? Somebody who will be as devoted to our children as we are. And of course, there's nobody who would be as devoted, but we want to get as close as possible. We want to protect our child from financial predators, and sometimes from themselves. They may not make good decisions themselves. And even though I'm a lawyer and most legal shows you see are people going to court, in this field, we want to avoid the court system if we can. And usually we can, unless we're dealing with limited conservatorships, and I'll talk a little bit about that at the end. Okay, so the big issue, and My presumption is that most of you have children who are under age 18. So, and if your child is over 18, you'll probably know a bit of what I'm about to talk about. And I want to give you just an idea about the public benefit system that exists now. When a child turns 18, all of a sudden they're considered an adult, which is really kind of funny. It's actually funny. We have a niece who's staying with us right now, and she just turned 18 yesterday. And I'm thinking about, wow, she's an adult. That's pretty, she's lovely and wonderful, but an adult, I'm not quite sure, right? But anyways, when you become an adult, a couple things happen. Your parents' resources and income is not attributable to you anymore. So all of a sudden you're poor. And because of that, you can qualify for a couple of public benefits. One of them is an income stream. Hopefully you can see my cursor here. It's called supplemental security income. And the other benefit you can qualify for is called Medi-Cal, which is California's version of the federal Medicaid system. Now, to qualify for these two benefits, you need to have under $2,000 of countable assets. So basically you need to be poor, okay? SSI provides an income stream of about $971 a month, which is imperfect, but it's helpful, you know, and that's supposed to pay for your food and housing here in the Bay Area, which is really funny, right? And if you get even $1 of SSI, you automatically qualify for Medi-Cal. And that's what people are usually very concerned about, because after your child turns 26, typically they're not allowed to stay on your health insurance program. Or if you pass away, there may not be a health insurance program for your child. And so we want them to qualify for Medi-Cal. There's a couple of other public benefits programs that you should be aware of. And these are not needs-based. These are programs where somebody has paid into the system and then someone's entitled to receive benefits. So one of them is Social Security Disability Insurance, Ssdi. And it's horrible because the names are almost the same, right? You have SSI and Ssdi. When a client comes in, I ask, what does your child receive? And they say, oh, Social Security. And so you actually need to find out which one, because it's actually very important. SSDI means that someone paid in for a certain number of quarters, and now maybe they retired and then their child receives benefits under theirs, or maybe they worked for a while themselves and then became disabled, and so they're entitled to an income stream. And after 2 years of receiving SSDI or the program, if you're a child of someone who retired, which is called CDB, Child Disability Benefits, after 2 years, you qualify for Medicare. So we actually have some people who are receiving SSI and SSDI, and/or they're receiving Medi-Cal and Medicare. Now, the type of planning that I'm going to be talking about, we do planning for all of these, but it's particularly important when you're talking about needs-based planning, because here's the issue. When you die and your child inherits money, now they have more than $2,000 of countable assets, and they get bumped off these really important public benefits programs. These programs are really intended for someone who can't work and support themselves. That's why those are the two things you get when you're working, really. You get an income stream and you get health insurance. So if you're not able to work and support yourself because you're disabled, then this is what you get. But if you receive an inheritance, you're bumped off of that. So what do we do? How do we plan so that someone can receive an inheritance and yet they can continue to receive these very important needs-based public benefits? Well, you create a special needs trust, okay? So this is, I think of a trust like, it's like a basket. It holds things, but it's a contract. It's an agreement between the person who set up the trust and the person managing the trust for the benefit of the beneficiary of the trust. With a special needs trust, it's irrevocable, which means it can't be changed. And that's very important because the reason why a special needs trust works, you can put like $1 million in a special needs trust, but the important thing is that the beneficiary cannot act as trustee. they can't manage the trust. They can't access the money. They can't take money out. They can't revoke the trust. And because the beneficiary, the disabled person, can't control the trust, it doesn't count as their money for public benefits purposes. So they could have $1 million sitting in the special needs trust, and none of it counts towards that $2,000 of countable resources that they're allowed under this, under SSI and Medi-Cal. So it's really a wonderful thing to set up for your child because it doesn't interfere with their public benefits. So I think of it like a safety net. You know, public benefits provides all that it can, and then the special needs trust supplements whatever they might need. Okay, there's two main types of special needs trust. There's actually a third, but I'm not going to go into it that much. So there's a third-party special needs trust and a first-party special needs trust. And I just drew them, or use different pictures because they function a little bit differently. The one that you would set up for your children or your child is a third-party special needs trust because you are the third party. You are putting your money into the trust. So it's really talking, third party refers to the source of the money that's going into the trust. All right, so that's most frequently the type of special needs trust we see. A grandparent can set up a third party special needs trust for their grandchild. A friend can set up a third party special needs trust. Compare that to a first party special needs trust. That is a trust intended to hold the beneficiary's own money. All right, so if you have someone who was working for a while and then became disabled, they need to transfer their money into a first-party special needs trust in order to protect it. Or let's say they receive grandma leaves $50,000 to the grandchild who's receiving public benefits. That grandchild can turn around and put his or her own money into the first-party special needs trust. All right. There's some differences between the two that's important to understand. So we have the source of funds, where the money comes from. For the third-party special needs trust, as I mentioned, anyone can set it up except for the beneficiary. For a first-party special needs trust, that holds only the disabled beneficiary's money, and it can only be set up before the beneficiary turns age 65. Okay, or actually, the beneficiary can only put money into it up until they turn 65. The big drawback of a first-party special needs trust is this thing here, this Medi-Cal payback. All right, upon the beneficiary's death, for a first-party special needs trust where their own money went in, Medi-Cal wants their money back, and they will bring a lien against any remaining money in that first-party special needs trust to get paid back whatever Medi-Cal has paid for the beneficiary's benefit over their lifetime. So it's better to have a third-party special needs trust because there's no Medi-Cal payback provision for a third-party special needs trust. Upon the beneficiary's lifetime, death, then the money goes wherever the person who set up the trust originally says. So it goes to the other sibling, or it goes to a charity, or it goes wherever they choose. None of it goes to Medi-Cal. Okay, there's a third type of special needs trust that I mentioned, which is a pooled trust. We call it a pooled trust. And the idea is that a lot of smaller first-party special needs trusts are pooled together. And when I say smaller, I mean they just don't have that much money in it. They're pooled together, and a nonprofit typically runs this and has a case manager who acts, making the distributions. And this has the same rules as the first-party special needs trust. However, if you're over age 65, you can put your money into a pooled trust. Okay, so the biggest question that typically comes up is, who's going to be successor trustee of my child's special needs trust? So initially when you set it up, you are the trustee, but the trust doesn't get funded immediately, typically, because while you're alive, you are the special needs trust. You're providing everything that your child needs. You know, you might be giving them a little bit of cash, even though you're not supposed to, but a lot of people do, right? But what happens if you're not there? to manage the money and to make these choices. Who's going to be your surrogate? Okay, and this can be a really difficult question to answer. So typically when I meet with somebody, you know, we go through the different choices. You could choose a family member or a friend. Usually I advise against choosing a sibling, a typical sibling. For example, I have, you know, my 7-year-old Caleb, and then I have a 6-year-old named Isaac who's more typical, but I would never name Isaac, once they're older, as a trustee of Caleb's special needs trust. That can really put the typical sibling in a difficult situation because now they feel like they're the gatekeeper of the money instead of the loving sibling who gets to support them, okay? So you have to be really careful with who you choose as trustee for family dynamics. You also want to choose somebody who's responsible, pretty good with money, and who really cares about your child. And sometimes that just doesn't exist for any number of reasons. So there are also professionals who act as trustee. There are private professional fiduciaries, and those are individuals who act as a trustee, and they're licensed through the state. And this is what they do, and they can do a very, very good job. One benefit is they tend to not cost as much money as a bank because typically they charge hourly. But a drawback is that we don't know what their succession plan is. Usually they're in their 40s or 50s or 60s, and your child will probably outlive them. And so you need to find out, okay, who's going to take over their practice when they're gone, and are you comfortable with that? Okay. So then another option is a bank or a trust company. And there are a few banks that act as trustee of special needs trusts. Not all banks, but there are a few. I think Wells Fargo, Fremont Bank, I believe Burrell, now Boston Private acts as trustee, but not all banks do. And so you need to do some research about that. There are a few nonprofits that act as trustee. JFCS does, Good Shepherd Fund. I found that they tend to be very busy, so sometimes they may not have as much availability for your child. But it is another idea. We talked about a pooled trust. You can also combine them. You can say, I want a family member to act as co-trustee with a bank. And then the bank is doing the heavy lifting and filing the annual income tax returns and keeping accountings and doing everything that's needed. And then the family member is making the distributions. But one issue is the nice thing about a trust is that it doesn't go through court. But the drawback about a trust is that it doesn't go through court. We like the court process when it provides oversight. So we make sure that your child is really being protected. With a special needs trust, there's no one overseeing the trustee. However, you can set it up so that there is somebody. And I found that the idea of a trust protector has become very popular recently. So a trust protector is typically a family member who doesn't want to act as trustee, and they don't have the availability, or they don't want to have that strange dynamic that comes up when you're, you know, the gatekeeper for somebody else's money. But they can, they get yearly accountings, and they have access to the books for the trustee, and most importantly, they have the power to remove and replace the professional trustee with a different trustee. So if things are going south with the current trustee, they can change it out. So they really do provide that oversight that's often needed. So that could be a very good role for a sibling, for example. Okay. One thing that was popular for a while was the concept of an advisory committee. This is when you name 4 or 5 people in different roles, say, you know, the psychologist and a case manager and a family member, and they all meet once or twice a year or every other year, and then they advise the trustee on distributions and on, you know, the most recent surgical procedures or that sort of thing. It just tends to be very expensive to get everybody together and you pay all of them. So that's really fallen more out of favor. Okay, I always recommend that parents write something called a Memo of Intent. And this is really a letter. This is separate from the trust. Okay, this is a separate letter that the parent writes to the successor trustee. It's like, dear trustee, these are the things I think you need to know about my child, okay? What makes them happy? What makes them really angry? You know, do they have any food allergies? Where would you like them to live? What have you looked into? Are there family members or friends that you really want them to stay involved with? And what are their favorite activities? Do they usually participate in Special Olympics? Do they like going to Disneyland? Who usually travels with them? These sorts of things. They're things that you've learned about your child over the years. And they're so important to pass along. And we don't want the trustee, especially if it's a bank or a private professional fiduciary that doesn't know that much about your child, we don't want them just dropped into this role with no idea, especially if your child has trouble communicating. Or if you know something about your child, about their meds, or something that the child may not offer as information. Okay, so I want to pause there. Whoops, how do I don't even know how to go back. Page up. That's how I do it. Okay, good. I'd like to pause there. And Gloria, are there any questions that have come up?
Yeah, we have a few questions here. So can a child under 18 and an immigrant qualify for SSI?
So, you know, that's a good question. I believe that, I mean, a US citizen definitely can. A child on a green card, I'm not an immigration lawyer, so I don't know the ins and outs. So I would need to look into that a little bit more.
Okay. And then Sanda has a few questions. Sanda, do you want to unmute and ask your questions? Sanda?
Oh, I don't know if we can unmute.
I have given participants
okay, great.
ability to unmute, but well, I'm going to read her questions while,
okay.
Meanwhile, if the child is left as a beneficiary to a family member's life insurance, what will happen to his medical benefits? If he has a special needs trust, is he limited on what he can spend it on? And then also a question about how CalABLE Act works.
Okay, so we'll get to the CalABLE account in a bit. The first question, let's go question by question. Do you mind reading the first one, Gloria, one more time?
So the first question is, if our child is left as a beneficiary to a family member life insurance, what will happen to his medical benefits?
Right, okay, so that's a very good question. So on your life insurance, the way you leave it to a child properly is you update the beneficiary designation form and you name their special needs trust as the beneficiary. Okay, now I'm actually going to take a little sideways maneuver here because I want to talk about the way that the special needs trust has to be structured for this, okay? Sometimes people draft what we call a testamentary special needs trust, which means that the special needs trust is embedded within the revocable trust for the parents, all right? That I don't recommend. Usually I recommend that you have a standalone special needs trust that's separate from the revocable trust. And there's a couple of reasons for that. One reason is that testamentary trust only springs into being at the death of both parents. So if you want a grandparent to be able to leave money to that special needs trust, or if you have a life insurance policy that you want to go to that special needs trust, it needs to already be up and running. And so it needs to be a separate standalone special needs trust. Okay, and the other reason why I do a standalone special needs trust is because, and I think this one's even more important, is after you die and the special needs trust gets funded, Social Security Administration will want to see a copy of it. And if you send them the full revocable trust of the parents that has many different provisions, and then also Section 6, it has the special needs trust embedded in it, they get very confused and they don't know where the special needs trust stops and where the other parts start. And sometimes they ask you to cut and paste it. And so it's just very difficult to deal with the government in that way. So I always do a standalone special needs trust. So definitely if you already have your estate plan set, you go back and look to see how your how the special needs trust is structured. Now, if someone has a life insurance policy and they've already left it to your child and they've already died and your child receives it, then the child can turn around and put that money into a first-party special needs trust. So that's a great example of when a first-party special needs trust will be very useful. And if they do that, then they can continue to get their Medi-Cal benefits.
Great. Now, the second part of her question was, if the child has a special needs trust, is he limited on what he can spend it on?
Well, so what's very important, first of all, to know is that the child is not making the decisions on spending the money. That's the trustee, who cannot be the child, right? That's why the trust qualifies as a special needs trust and it can continue to receive the public benefits. But the trustee can spend the money on just about anything. It's very, very broad, all right? There are some restrictions when it comes to if the child's getting SSI, but I'll talk about that in a little bit, and because there's a way around it that's pretty new and pretty exciting for us estate planning geeks. Okay, and then the third question is about CalABLE, and I'll get to that soon.
Okay, well, there's a long list of questions. I don't know if you want to continue with your presentation, and we'll save everything until the end. Yeah.
Yeah, if we, we'll pause again soon, but if we hit more of the answers to those questions, that'll be helpful. Okay. All right, so I want to talk about a recent development with retirement accounts. And some of you may be aware of the Secure Act that was just passed in January 1st of this year. There are some good things about the Secure Act, but then there are some drawbacks. Okay, the good things are you don't have to start taking your required minimum distributions from your retirement accounts until age 72, as opposed to age 70 and a half. So that can be really beneficial. But one of the big drawbacks is if you're a child and you inherit a retirement account from your parent, you used to be able to inherit it and then stretch out the benefits over your lifetime and only have to pay taxes on the required minimum distribution as calculated to your lifetime. That has been eliminated, and now you can only stretch out the benefits over 10 years. After 10 years, the child who inherits needs to pay all the taxes, all the income taxes on that retirement account. So we're talking about IRAs, 401ks, 403bs. This doesn't apply to Roth IRAs because that's post-tax. The tax has already been paid. However, there's a wonderful exception. There's actually a few exceptions, and one of them is that a disabled person or their special needs trust that's listed as the beneficiary for a retirement account can still stretch out the benefits over the disabled person's lifetime. That's really, really good. So it hasn't eliminated the option of stretching them out over the lifetime. So as a result, more parents are really looking at this again, and they're saying, okay, I have this big retirement account. Do I want to leave it to my typical child or my special needs child or both? A lot of times now, the parents will name the disabled child, their special needs trust, as the beneficiary, because that child will get better tax benefits as opposed to naming the typical child. And then maybe they'll offset that by leaving more in the revocable trust or leaving other accounts to the typical child to balance it out. But it's a really great planning strategy that we have now that's only available really for typical kids. Also for spouses, they can still stretch it out over their lifetime. For minors under age 18. So there's other exceptions, but we're really focusing on planning for special needs. Okay, so we've gotten there. ABLE account. Okay, what is it? So an ABLE account, and you're saying, well, what's the difference between CalABLE and ABLE? Well, CalABLE is our cutesy name for an ABLE account. Each state gets to create their own ABLE account, and ours, we only get one, and ours is called the CalABLE account. Whoops, I didn't mean to go on. There we go. It's a savings account for disabled children and adults, okay? So here's how it actually developed. What happened was, and I'm gonna move this, hold on, there we go. There was a group of parents of children who were adult children with Down syndrome in Virginia. And those children were working part-time, but they had to spend down all of their money every month down to under $2,000 a month so that they could continue to qualify for SSI and Medi-Cal. And the parents were saying, this is not fair. And the kids were saying, this is not fair. In America, we want people to be able to save up and, you know, be able to save up for a car or for a nice TV or whatever it might be. And so they spoke with their congressperson, and there was great bipartisan support for this ABLE account, which stands for Achieving a Better Life Experience. So the idea is a disabled person can have an account, one account, you don't get more than one account, and that account can receive up to $15,000 each year, post-tax money, and then it grows tax-free. And if you withdraw it for qualified expenses, you don't have to pay any of the capital gains tax. It's modeled after a 529 plan, if you're familiar with those. In fact, it's called a 529A plan. And anything in the ABLE account does not interfere with public benefits, just like a special needs trust. Okay. The other really nice thing is it counts as the child's money for SSI benefits. So we'll talk about that in a second. Okay, so to be eligible, the beneficiary must have a qualifying disability, and the big limitation here is that disability must have surfaced before age 26. So there are some disabled people who maybe they were disabled in a car accident later in life, or maybe they have a mental health challenge that didn't manifest until age 30, okay? But as long as the disability started before age 26, you can get, and you're disabled, which either the doctor writes a letter, or if you're receiving SSI or Medi-Cal benefits or anything, or Ssdi, then you do qualify as being disabled. It's meant to be used for qualified disability expenses, and that's very broad. That's really anything people need to live off of. However, it's a little bit limited, so it's not meant to pay for a trip to Disneyland, or, you know, a coin collection, you know. And then, as I mentioned, only one ABLE account per individual. All right, so you can contribute up to $15,000 a year from all sources. So what that means is it can only receive $15,000 a year. This is important, all right? You can't have mom contributing $15,000 and dad contributing $15,000 and grandpa contributing $5,000. Once it receives $15,000, that's capped off for the entire year. And then the next year you start over and you can contribute another $15,000. All right, then over a period of 6 or 7 years, if it exceeds $100,000, then that child's SSI benefits are suspended. However, they can continue to receive Medi-Cal, all right? And the ABLE account was designed to, so that Medi-Cal or Medicaid programs can bring reimbursement claims against it, like a first-party special needs trust. However, we have allowed, the program allows states to opt out of the Medi-Cal reimbursement. And California is one of the several states that has opted out. So what that means is Medi-Cal will not go after your child's ABLE account when the child dies. That's really, really nice for us. So where do you go to set up a CalABLE account in California? You don't just go to Wells Fargo and say, hey, I want a CalABLE account. They won't know what you're talking about. Instead, you have to go online, and here's the site, calable.ca.gov. That's it, and it takes you to, this is the screen that you'll find, at least, you know, a few weeks ago. And you hit open an account, this big red, orange button. You will need the beneficiary's social security number. If the beneficiary is not the person who's going to be managing the money, you know, if your child is under 18, then you need the legal representative, your social security number, and also the bank account information. So you will set up a bank account at a different bank, and that will link to the CalABLE account, which is basically the back-end account that TIAA-CREF runs, okay? Nowadays, they do have a Visa debit card that's available that can be used to make payments from a CalABLE account. So that makes the turnaround time a lot faster, which has been very popular. Okay, so I think that's all the information on CalABLE. Oh, I wanted to compare the two. So I have a couple charts, and I will email Gloria a copy of this presentation, so you don't have to furiously write all of this down, but you can see how you compare them. So the ABLE account and the third-party special needs trust are meant to act alongside each other. They're useful for different things. The third-party special needs trust is useful for receiving an inheritance. All right, so if somebody dies and leaves $1 million, that $1 million can't go into the ABLE account because the ABLE account can only receive $15,000 at a time, right? The ABLE account is really meant to be more like an up and running account that the disabled person can use or somebody else can use for them. And here's a really cool thing that you can do with an ABLE account. Okay, so if you're familiar with SSI, SSI is meant to pay for food and housing. That's the $971 a month income stream. If somebody else is paying for food and housing, for example, if your child is living with you and you're paying their rent, or you're paying for their food or both, then their SSI payment is decreased by about 1/3. It goes down to about $550 a month, all right? However, if the payment for their food and rent is coming from an ABLE account, which counts as their money, as opposed to somebody else paying for their food and housing, then the SSI payment is not reduced. Okay, so here's what you end up seeing. The third-party special needs trust is up and running. It distributes $1,000 a month or $1,250 a month to the ABLE account. And then the ABLE account turns around and pays for the food and housing. In that way, you can preserve your SSI benefits. Very cool, huh? We love it. Okay. So I have a chart comparing these. And I think I went through all of these things. So I'd like to take a pause and see if there's any questions, especially on the CalABLE account.
So I think that there is a related question. The question was, do we have to pay taxes on the special needs trust? I think you have that on the chart somewhere, I believe.
So here, how is income taxed? All right. So with a third-party special needs trust, it gets its own separate tax ID number, and you have to file income taxes on a 1041 form every year. The trustee is required to, not the beneficiary. Okay. For income that's generated inside the third-party special needs trust, if that income is distributed out to the beneficiary, then the beneficiary reports that income on their K-1 form. However, that income does not count as income for public benefits purposes, okay? Now, if the income stays in the special needs trust, then the income is reported on the 1041 form. Does that make sense?
Okay. Yeah, I think that answers the question. There's another question about how much does it cost to set up a third-party special needs trust?
Mm-hmm. So, I mean, it depends on the attorney. I charge a flat rate. Typically, when I'm doing planning, I do the full estate plan, because usually you need to change the revocable trust as well. And I'll be talking a little bit about the revocable trust. And the flat fee really depends on what needs to be done. So that's something that I could speak about individually. Okay.
Now there's a question about if the disabled individual has a job, where does the income go? You know, if this person also has a third-party special needs trust, I believe that's where the ABLE account comes into play.
Yes, exactly. The income can go into the ABLE account. And the other really nice thing is if you're receiving, hold on, do I have that? I think I put that down somewhere. Okay, well, this is something that's kind of new. If the child is working and supporting themselves, well, not supporting themselves, but they're working, they can contribute an additional up to about $11,000 a year into the ABLE account, in addition to the $15,000. That's only if they're not participating in their employer's retirement plan. So it's kind of like they're getting to save up a little bit more for retirement. So now the ABLE account can receive about $26,000 a year. You can't put the child's own earned income into a third-party special needs trust, because the third-party special needs trust can only receive money from people other than the beneficiary.
Right. Now, this parent wants to know if she needs to have a trustee in mind in order to start the trust.
Not necessarily. A lot of times it's helpful just to have a conversation, to talk about what are the different options, and then sometimes I provide some names of private professional fiduciaries or contacts at banks that you can interview. It's a process. So I'd say don't let that stop you from starting the process. It's so hard to overcome that. I can't tell you how many clients come in and they say, oh, I should have done this 10 years ago. Me too. I have a funny story. Okay, so I've been doing this for 11 years now, and it was only 5 years ago. So that's after 6 years of practicing in this field. It was only 5 years ago that I actually set up my estate plan. so no judgment. It's hard to, especially we just couldn't decide on guardians for our minor children. And I still not crazy about who we listed, although I love them to death. I just don't know if they're the best choice. But we're like, okay, let's put somebody down, and we can always change it. A revocable trust is amendable and changeable. So I'd say, definitely get started, but be thinking about these things. I think that's great.
Right. I think that's good advice. So don't let that stop you, get that process started. I think that's great advice. Is there any way that the child can have either full or some kind of control over their inheritance? My child has mild to moderate autism. This is a question.
Okay. Yeah. So one thing that I put in the trust sometimes is kind of a toggle switch, because we don't know. Because actually my son is quite high functioning, and I think he will be able to work and support himself, but you never know. So I put in a little switch where I say it's the trustee's discretion. Okay. So when the parents die, if it looks like that child's going to need needs-based public benefits in the future, or if they're receiving them, then their inheritance goes into the special needs trust. If it looks like they're not going to need that, then it is distributed the way the other children's money is distributed. And then I also put in the special needs trust. So if a special needs trust gets funded, and then, some kids are just late bloomers. And then, once they're 30 or so, they kind of get their act together and they're able to manage their trust. There's great development in different things. Then the trustee has the discretion to distribute the money outright to the child, or to be held in a less restrictive trust. The main restriction of a special needs trust is it's not supposed to distribute cash outright to the child, because that can interfere with public benefits. Otherwise, a special needs trust really acts just like a supplemental trust that maybe you'd set up for a child who doesn't manage money well, or there's just a lot of money there and you don't want the child to access it. You want somebody else to manage it for them. There aren't that many limitations. I think there's a rumor going around that special needs trusts are super limiting. I don't think they are. I mean, the two big limitations are the child can't act as trustee, and it's not supposed to distribute cash. But it can be used to buy really anything that child needs. And so it's quite flexible.
That's good to know. Now, can other relatives contribute to the special needs trust that the parents had set up? Or
I think that's a great idea. Yes. So when you set up a special needs trust, you should let all your family members know, hey, CalABLE now has a special needs trust. So can you please modify your own estate plan? So if you're leaving anything to CalABLE directly, it can go to a special needs trust.
Okay.
So I realize I have a couple more topics that I want to talk about. So can we do that, Maria, and then we'll circle back?
Definitely.
Okay. Wonderful. Okay. So I would like to talk now about your revocable living trust. And many of you already have a revocable living trust, which is great. Okay. The main goal is to avoid probate. If in California, if you have more than $166,250, in your name that doesn't have a named beneficiary and it's not part of a trust, then it goes through the probate court. And as I mentioned before, we love to avoid the court system. It's costly, it's time consuming, it's public, nobody likes it. Okay, so in the trust, you say who you want to be successor trustee of your stuff. And you also say where you want your stuff to go upon your death. Okay, so, you know, equally to your kids, and then Caleb's goes to his special needs trust, that sort of thing. There have been some changes in the last 10 years that I wanted to go over, which you may not be familiar with, just so you know. Okay, so this is what a typical AB split looked like before around 2012, 2013. Okay, so you had the family trust, and it would split into two sub-trusts, and this is the deceased person's half. The first person to die goes into the bypass trust, and the survivor's half goes into the survivor's trust. The bypass trust is irrevocable, it can't be changed. So it's actually good for control purposes. If you're in a blended family and you want to make sure that if you're the first one to die, your half goes to your kids, this can be a good structure. But really, it was used at that time because the estate tax exemption was very low. It was only about $1 million for a long time, and anything above $1 million was taxed, and it was like use it or lose it. So either you captured it in the bypass trust, or it disappeared. There was no what we call portability. And then at the second death, things went to the children. Okay, so here's the big change. All right, we got the thing called portability. So that means that the survivor can say, hey, I want the deceased person's estate tax exemption. And they can port or transfer the unused estate tax exemption to the survivor. So now the survivor has double the estate tax protection, and they can have double the money. So now everything, you see, everything can go to the survivor's trust. Now that's not as good for control purposes, because the survivor can decide, hey, I'm going to remarry and leave things to the, you know, the new spouse or the new kids. But if you both have your children and, you know, they're joint children and you're not too worried about that, it's much simpler to simplify this and make it all go to the survivor's trust. And then on the second death, things go to the kids. Okay, so a lot of people are updating their trusts to provide that simplification. Also, the estate tax exemption is much higher now. Believe it or not, if you haven't heard, it's $11.58 million per person. So for a couple, you can protect up to $23 million, which unfortunately most of us don't have an estate tax issue, right? In 2026, it's scheduled to go down to $6 million per person. Okay, so how should children who are not disabled receive their inheritance? Because many of us, just like me, have typical children who may be more, who are sometimes more difficult, I have to say. You know, they have a twinkle in their eyes. My 6-year-old now says, his name's Isaac, and he says, we need to call him Pokey Isaac because he's so into Pokemon. Now he wants to be called Pokey Isaac. I'm like, all right, but you know, creativity is great. So how should the children receive their inheritance? Well, one way is to just say, hey, they just get it outright. Or maybe they get everything at age 25. Sometimes people stagger it. They say, well, they can get a third at age 25, a third at age 30, and a third at age 35. Another option that I'm seeing that's more popular nowadays is to leave everything to what we call a lifetime trust. So this is a trust that lasts for the child's lifetime, and the child can become trustee of the trust. So the child manages it, but since it's held in trust form, it doesn't count as the child's money, so that if the child endures a divorce, the money is all segregated for the child. If there's a creditor's claim against the child, this has a high protection against creditors' claims. So lifetime trust can be very powerful. And then also, you know, there can be a special needs trust for your disabled child. The other thing to think about is the alternate distribution. When you have children, typically you're not thinking about what if our kids die at the same time as us, or what if, God forbid, they die before us, right? So you want to put down where things go if all of your descendants are deceased. Okay, so last thing I want to talk about very briefly are conservatorships. Let me just go through this quickly and then we can answer all the rest of the questions. So there's several types of conservatorship. So now I'm shifting completely, and now we're actually going to talk about the court process, okay? When you have somebody and you need to make decisions for their benefit and take away their ability to make their own decisions, we call that a conservatorship, all right? When you're dealing with a child who's developmentally disabled, once they turn 18, before 18, you make their decisions. But then once they turn 18, the challenge is you may not be allowed to go to their IEP anymore, right? Or the doctor won't talk to you, or you can't sign documents on their behalf. So a lot of times you'll need to, you may conserve your child. Not every child needs a limited conservatorship. So it really depends on the situation. The two main situations that I see that come up where people really want conservatorships is if their child is not cooperative when it comes to medical decision-making and they need a big surgery or something, or the parents are really concerned about financial predators, that child will enter into a contract and spend a whole lot of money. Or the child just has very low capacity and they're not able to make their own decisions, then you get a limited conservatorship. This allows you to access the information and make decisions for them. Okay, limited conservatorship is called limited because the court wants developmentally disabled individuals to be as independent as possible. So you have to ask for each power that you want over that child. So the 5 powers that people typically ask for is the power to determine where they live, power to access their confidential records, power to enter into contracts, medical consent, and education decisions. And you have to give reasons why you should have that power. So it's not just a slam dunk like, hey, my child is on the autism spectrum, I get a limited conservatorship. You actually have to give examples of, my child can't count change. They can't take a bus home. They have, they really can be taken advantage of in these different ways. Now, there are 2 powers that they're just not going to give you, usually, at least in San Mateo and Santa Clara counties, power over sexual relationships and whether or not your child gets married. The court really wants your child to be able to make those decisions. So this is the general procedure. And I'm not really going to go through this, but these are the steps you can go over later when I send out the presentation to Gloria. So what if you don't conserve your child? Well, once they turn 18, you should get them to sign a healthcare directive and a durable power of attorney. By the way, we should all have those documents. That's if you're alive but you're sick, then somebody else can sign financial documents on your behalf and someone else can talk to the doctors for you and access your medical records. All right, so everyone who's age 18 or above needs to have those 2 documents. They are available online, so if you want to just do some quickie ones for your adult kids, that's fine, but make sure that they have these. And then another thing that's becoming more popular is called supported decision making. And there's a website here, I'm not really going to go into it, but that's basically where you get a team. It's a team approach, getting a group of people together who help the disabled adult make good decisions. So you're not going through the court, it's not a conservatorship, but you're getting a support system in place to really help that adult to succeed and thrive. And it's been very popular in some circumstances. Okay, so I have some examples that I think can be illustrative of what we're talking about. So you can kind of think about all the different things that we've discussed and what do we need? Okay, so first we have John Mckinley, who you might recognize him from Scrubs. And he and his wife have 3 kids. His adult son has Down syndrome, and then they have 2 typical minor daughters. So what planning do they need? And usually I'd, kind of, hey, why don't you guys tell me? But you're all muted, so you can't. So, so they would need a revocable trust. They need a special needs trust for their child. The 3 adults need durable powers of attorney and advanced healthcare directives. They should have an ABLE account for their child. There's another, they need pour-over wills. I didn't talk about those, but in the pour-over wills, they would nominate guardians for their minor children. Then there's a couple ancillary documents as well, but that's really, they need the full complement of estate planning documents. And hopefully, the things that I just described, they kind of ring a bell since we've talked about most of those documents here. Okay, so now we have Sarah Palin. And she, unfortunately, she went through a divorce, and she has a minor son with Down syndrome and some adult children. So there are certain steps that you should take if you're going through a divorce or if you have been divorced to revoke your joint estate plan and set up your own revocable trust. And then a special needs trust for her son, Trig. She can set up an ABLE account for him. She needs her own healthcare directive and durable power of attorney. He doesn't because he's not 18 yet. Oh, and with the Mckinley family, I don't know if they're going to get a limited conservatorship over their son. That's something to consider. Okay, third example. So you may know, or you may not know, that Jamie Foxx has a sister with developmental disabilities. And I saw a video of her. She seems fabulous. And so what planning can Jamie do for Deandra? So they can do, Jamie can set up a third-party special needs trust for Deandra and leave, whatever he'd like for her. It doesn't have to be a parent setting it up. It can be another family member. He can help her set up an ABLE account. She should she has pretty high capacity. She should have an advanced healthcare directive and durable power of attorney. So those are certain things that she might need. Okay, so I'd like to open it up to more questions. We have, boy, just 3 minutes, but I'll keep this open for as long as you'd like. And if you need to leave, that's totally fine, but I'll keep going because I like answering questions. I'm a lawyer. I like giving my opinion. It's kind of fun.
So we have a question here about registering a trust. Do we need to register a trust? And also, once a trust is set up, can we change it from time to time?
Okay, so no, you don't need to register a trust. In other countries, you need to register your wills, but here in California, all estate planning documents are private. And that's really good, except when it's not good, because sometimes we get requests like emails sent around saying, hey, I'm looking for a copy of the Jane Doe Trust. Did anybody do that? And so it can be hard to locate. So make sure that your successor trustee at least knows where to find your trust or which attorney you worked with so that they can find it. But it's a private document. Nobody's going to find it. And yes, you can, for your revocable living trust, you can revise it at any time while you guys are alive and have capacity. I'm working on somebody they just did their 6th amendment and restatement, so these people change these documents quite frequently. I recommend going in to see your attorney every 3 to 5 years. Or when, just to make sure, hey, is everything current? Make sure that the successor trustees that you've named are still the people you want to name. Any charities are still around. If anybody died or was born or you inherited anything, these are all good reasons to go into your attorney.
Great. This parent wants to know, what are qualifying expenses for the ABLE Act?
It's most things that you would need. I don't have a list of all of them, but it's transportation and medical expenses and anything that you would need to do in your daily activities, basically. So it's actually very broad.
Okay, that's good to know. Is high functioning autism considered a qualifying disability for the ABLE account?
So it depends. It's so interestingly, when you're talking about disabilities, it's not the diagnosis that matters as much as whether that diagnosis means that your child is not capable of working and supporting themselves due to the diagnosis. Okay, so someone can be on the autism spectrum and be working and supporting themselves. They would not have a qualifying disability. Stephen Hawking, even though he was profoundly disabled physically, his mind was sharper than any of ours combined. And so he would not have had a qualifying disability. But you know, other people with ALS or on the autism spectrum could have a qualifying disability. So it really depends on the severity and on whether it impacts their ability to work.
So in order to open an ABLE account, do you need some kind of certification from a physician to say that your functioning capacity is impacted by the disability?
You're supposed to have a letter on file.
I see.
Nobody's checking it, by the way, but you're supposed to have it in your records.
Okay. So this parent is interested to know more about the 529 College Fund, how you can move money from the 529 College Fund to the CalABLE account without penalty.
Yes, you can. So, you know, certain people have encountered this where they've set up a 529 plan for their child and then later discover that their child has developmental disabilities and may not be going to college, and they'd rather have it in the 529A plan. You can transfer up to $15,000 a year from the 529 plan to the ABLE account without any penalty.
Okay, great. And then one last question here. Let's say you've set up a special needs trust fund and ABLE Act account and conserve the child, but then later on it looks like the child is able to function on his own. What happens then?
Well, you know, if you have some language in the special needs trust that says that it can be distributed outright, if the child's able to work and support themselves over like a period of 2 years, then you can distribute it. Otherwise, you're probably going to court to distribute it out. Okay. Or it stays in the special needs trust and it just functions as a support trust.
Great. Well, thank you, Ellen. I think we've covered most of the questions here. I'm sorry if I didn't get to everybody's questions, but Ellen has her contact information up on the screen, so you can all feel free to contact her directly. And I just want to thank you again, Ellen, for spending time with us this afternoon. We've all learned a lot. Thank you so much. And I will send the slides to our attendees and also a link to the recording so we can go back and review all the information Wonderful. That you've covered today. Thank you so much, Ellen. And thank you, everyone.
I appreciate it.
Thank you. See you guys later. Bye-bye.